if history was everywhere. It was simply a judgment about how people should behave and how people were likely to behave. And to put onto the shoulders of a woman in that kind of a world the duty to, after the first year, start looking around to see what her colleagues are making, which will guarantee that there won't be a second year, is exactly the wrong way to have done it. And it's a lack of empathy.
Can I just ask for 1 second? It sounds to me like we're conflating, maybe I'm wrong, but that Burt and John, you're talking about empathy and imagination as similar. That empathy doesn't have to mean I was a woman and I was discriminated against. Empathy can mean I'm listening to Ruth Bader Ginsburg losing her mind here at oral argument, and I'm hearing what she's saying, and there's something that I don't know. Is that, I mean, I'm thinking now of the Redding case, of the strip search case that the court heard earlier this term, where really Ruth Bader Ginsburg was losing her mind. She could not believe that some of her male colleagues were describing a strip search as analogous to Animal House antics, you know, the kinds of stuff that happens to guys in locker rooms. And she was visibly frustrated and then got off the bench and gave quotes to Joan Biskupic that were palpably upset. And the one thing I thought about at the time was, she's forgetting John Paul Stevens, right? Who, as an 89-year-old male, has never, I don't think, been strip searched, and certainly was never a 13-year-old girl, but who was as sensitive as she was at that oral argument to the experience of this 13-year-old girl. And I'm just wondering if we're missing this nuance of empathy doesn't have to mean only girls get what it's like to be discriminated against. It can also mean having the ability to understand or to listen when someone says something. Am I making this
No, that's
complicated?
exactly right. That's why Brennan was a great justice. He was empathetic. He had never been a woman. He had never been a black person. He had never been a poor person. But he was astonishingly empathetic to people who walked in different shoes. And I think that's all Obama means. It isn't that you should be good to your tribe. It's that you should be willing to try to understand how an opinion plays out in people's lives who've been just lived differently than you have.
I think, that's why I used the quote from Justice O'Connor, which only goes to that understanding, that it's saying what it is you can, know about yourself and what you don't know, and then you can actually learn something about something other than yourself. The litany of how legislators and voters and judges have different roles about making decisions, I think left out another category, which is jurors. Jurors are told they have an obligation to do something. They're not just supposed to vote however you feel. You're actually supposed to do the following. And anyone who served on a jury knows that jurors actually, one of the dynamics is they have to listen to each other if they're going to actually be able to reach a unanimous decision. So you actually have to listen to somebody else, or this just breaks down. One of the qualities that I think is in what I care about here is the ability to, and the responsibility to actually have to do that. Okay, what you just said, Dahlia, about you're not a girl, but can you work, and do you realize you actually have a responsibility to try to know what it would be like for that girl, okay? It's those two things. Can you do that? Because people can say they can, but they can't. And do you realize that's actually important? My example of Herbert Wexler was he did not acknowledge the responsibility, nor do I think he could have done it. Okay? And I think that is very important to people we would want to be justices on our Supreme Court. The idea that the court can act as an umpire, I just think you're missing the point on some of the big cases. In some of the big cases that the court has, it is more experienced in this area than the litigants. Okay? It has decided these cases. They've been working together for a while. They know these cases inside out. So they know a lot of contours of this. The question about whether they can appreciate all of the nuances and all of the things that ought to go in there is a different decision. Okay, and it requires them to acknowledge it, as a responsibility, and then be able to do it.
She's shutting me
No,
off.
I'm, there.
What kind of empathy is
I'm turning
that?
you on. There you go.
Turning me.
Yeah, okay.
Okay.
Strike
Okay.
that from the record.
Yeah, I take it as my job here to lower the level of discussion periodically. So let me say that it's a bad idea to use a term that you have to explain 5 times a day. Okay, so I repeat that it should have never been used. And even in the context of the cases pertinently described by Burt and John, I would prefer, as I always do, a theological vocabulary. And I would get off of empathy and go to letter and spirit. And you can talk about judges who will, in fact, follow what they at least take to be the letter of the law, an impossible category in my view. And then about judges who are looking to the spirit within which the law was first conceived and then passed. That's why I'm an intentionalist. I am a hardcore intentionalist originalist, because harder core than almost anyone. There are about 6 of us in the world. Because it seems to me that what you always want to be looking for in doing judging is the spirit or intention within which the act was performed. And that was what was wrong with one of the many things. John hit many of them on target. I've taught that article innumerable times in my law school classes, the Wexler article. One of the extraordinary things about the Wexler article is that when he gets to the passage that John quoted, the passage when he distinguishes between the wish to associate and the wish not to associate, and declares them equivalent, at least in the context of his present puzzle. What he has done is removed these facts from history. They become facts in what I've called a moral algebra. One party wishes to associate, the other party wishes not to associate. No acknowledgement of the very dark history that has brought the people involved in this case to the court. That is a failure. That is a failure to, in effect, interrogate and try to be faithful to the spirit as opposed to the letter. So I would say there's no spirit